job. Older workers are also vulnerable to workplace discrimination and have become increasingly vulnerable to discrimination during the COVID-19 pandemic. Congress recognized the need to protect older workers from discrimination when in 1967 it enacted the Age Discrimination in Employment Act. But the Supreme Court severely eroded those protections in 2009 through its 5-4 decision in Goss versus FBL Financial Services. In that case, the court imposed a higher burden of proof than courts had previously required for age discrimination cases. And because of the court's opinion in Goss, workers must now prove that age discrimination was the sole motivating cause for their employer's adverse action, rather than just a motivating factor in their employer's adverse action. The Protecting Older Workers Against Discrimination Act is a bipartisan legislative fix that would restore the pre-2009 standard in age discrimination claims, thereby aligning the burden of proof with the same standards for proving discrimination based on sex, race, religion, and national origin. Congress passed this bill with bipartisan support last Congress, and just this morning I joined Chairman Scott and Congressman Davis in reintroducing it. Finally, I'd like to voice my strong support for the two other bipartisan bills under discussion today: the Paycheck Fairness Act, which this subcommittee and the Workforce Protection Subcommittee also enthusiastically advanced last Congress, and the PUMP Act, which I know Chairwoman Adams will cover in detail. The 4 bills we are discussing today take important steps toward workplace gender equity, healthy pregnancies, and improving the economic security of all workers. I thank the witnesses for their time today, and I yield to the ranking member, Mr. Fulcher, for his opening statement.
Thank you to all of our witnesses for joining us here today.
Mr. Fulcher, your sound is not clear, so we'll give you just a moment to see if we can hear you clearly. Mr. Fulcher, would you like to try again?
At this point.
Okay, I recognize Mr. Fulcher for 5 minutes for your opening statement.
Okay,
Mr. Fulcher, it's still not clear. In the interest of time, I'm going to go to Chairwoman Adams and then come right back to you, and that'll give you 5 minutes to work on your sound. I recognize Chairwoman Adams for 5 minutes for your opening statement.
Thank you, Madam Chair. In addition to the Pregnant Workers Fairness Act and Protecting Older Workers Against Discrimination Act, today's hearing will also examine the Paycheck Fairness Act and the Pump for Nursing Mothers Act, both of which are partially or fully under the jurisdiction of the Subcommittee on Workforce Protections. These bills address issues of basic fairness for women in the workplace. Today, women earn on an average 82 cents on the dollar compared to white men. The wage gap is even worse for women of color. For example, Black women earn an average of 63 cents on the dollar. Native women earn an average of 60 cents on the dollar, and Latina women earn an average of 55 cents on the dollar compared to white men. The wage gap persists in nearly every line of work, regardless of education, experience, occupation, industry, or job title, and that's unacceptable. From the North Carolina House to the US House for 3 decades, I've been fighting to close the gender wage gap. 58 years have passed since the Equal Pay Act was enacted, and it's been 10 years since President Obama signed into law the Lilly Ledbetter Fair Pay Act, yet the promise of equal pay for equal work remains unfulfilled. Excuse me. The Paycheck Fairness Act is an opportunity for Congress to strengthen the Equal Pay Act, bolster the rights of working women, and put an end to the gender-based wage disparity once and for all. The Paycheck Fairness Act would require employers to prove that a pay disparity exists for legitimate reasons, ban retaliation against workers who discuss their wages, allow more workers to participate in class action lawsuits against systemic pay discrimination, prohibit employers from seeking the salary history of prospective employees, and develop a wage data collection system and provide assistance to businesses to improve equal pay practices. The House passed this legislation with support of 7 House Republicans in the 116th Congress, and we look forward to passing it again this year. Nursing workers are in need of protections in the workplace to be able to maintain breastfeeding when they return to work. More than 10 years ago, the Break Time for Nursing Mothers Act was enacted, requiring employers to provide eligible nursing workers with unpaid break time and a clean, private space to pump. Unfortunately, gaps in the law limit the number of workers entitled to these protections and how workers can hold their employers accountable when they violate these requirements. The Pump for Nursing Mothers Act is a bipartisan bill that closes gaps that excluded nearly 9 million employees who are exempted from overtime protections. The bill also ensures nursing workers have access to appropriate remedies when their employers fail to provide break time and appropriate pumping space. It also clarifies that if an employee is not completely relieved of duty during a break, that time is considered hours worked for the purposes of minimum wage and overtime requirements. Every worker who chooses to nurse understands the importance of being able to express breast milk and the severe health consequences of failing to do so. This legislation is a simple improvement to existing law that will have a meaningful impact on nursing workers across the country. I strongly support all 4 bills under discussion today, and I will now yield back to you, Madam Chair.
Thank you, Chair Adams, and I now recognize Ranking Member Fulcher for 5 minutes for your opening statement.
Thank you, Madam Chair. I think I understand now how some of our remote students feel with some of their struggles in learning remotely. Thank you to all of our witnesses for joining us here today. Thank you again, Madam Chair. We all agree that discrimination in America's workplace is wrong and should not be tolerated. That's why there are laws prohibiting such egregious behavior. And while the purported intent behind this legislation is admirable, good intentions don't always bring good policy. Good policy comes from thorough examination and bipartisan collaboration. This hearing is far from thorough, as we are considering all at once 4 separate and distinct bills that make significant changes to very important laws. It's also not bipartisan. If my colleagues across the aisle were truly interested in bipartisan collaboration on these bills, they would have allowed more than 1 Republican witness to testify. This will not result in a fair or adequate examination of the underlying issues, and it certainly misses the mark regarding today's hearing title, Fighting for Fairness. Although today's hearing will cover a number of bills, I'll comment on one bill that is particularly troubling. The so-called Protecting Older Workers Against Discrimination Act is just another empty promise wrapped in a convenient title. There's no evidence or data that suggests this bill's needed. It's already against the law to discriminate in the workplace because of an individual's age. Congress has enacted significant laws prohibiting employment discrimination, including the Age Discrimination Employment Act, the Americans with Disabilities Act, the Rehabilitation Act, and the Civil Rights Act. Additionally, employment trends for older workers are positive in recent decades. In 2018, older workers earned 7% more than the median income for all workers, compared to 20 years ago, when older workers earned 23% less than the median for all workers. In Idaho today, workers 45 to 64 are earning 19.6% more than all workers in the state. This trend is expected to continue as we recover economically from COVID-19. The only parties likely to win if the bill is enacted into law are the trial lawyers. The bill will increase frivolous legal claims against business owners, thereby taking away valuable resources from efforts to prevent harassment and discrimination. The bill disregards current law, real-world workplace solutions, and Supreme Court precedent, ultimately rewarding trial lawyers at the expense of older Americans. I thank the witnesses for being here today. I hope as members of this committee, we'll be able to work together in the future on real solutions to real problems. Madam Chair, I yield back.
Thank you very much, Ranking Member Fulcher. And I now recognize the Ranking Member of the Subcommittee on Workforce Protections, Mr. Keller, for the purpose of making an opening statement.
Thank you to both of our chairwoman, Ranking Member Fulcher, and to all our witnesses for joining us today. I'd first like to associate myself with the remarks made by Ranking Member Fulcher about the structure of the hearing unfolding here today. Only allowing the minority to invite one witness for a legislative hearing covering 4 different bills is far from unifying and will not result in a thorough bipartisan examination of the important topics before us. I'd like to comment specifically on one of the bills being discussed today, H.R. 7, Equal Work Deserves Equal Pay, regardless of the sex of the employee. In America, this is the law. Paying women less than men for equal work is wrong and illegal. If employers are doing so, they are wrong and they are breaking the law. No one here disagrees with that fact. That's why Congress enacted the Equal Pay Act of 1963, which made it illegal to pay different wages to women for equal work. The following year, Congress enacted even broader non-discrimination laws, making it illegal for employers to discriminate because of race, color, national origin, religion, and sex in Title VII of the Civil Rights Act. These landmark laws are important affirmation of who we are and what we believe as a country. That workplace discrimination is repugnant and illegal, and quite frankly, discrimination of any kind in our country is unacceptable. H.R. 7, the so-called Paycheck Fairness Act, is a false promise that creates opportunities and advantages for trial lawyers, not for working women. Instead of treating sex discrimination charges with the seriousness they deserve, the Paycheck Fairness Act is designed to make it easier for trial lawyers to bring more suits of questionable validity for the purpose of siphoning off unlimited paydays from settlements and jury awards, lining their own pockets and dragging women through tedious, never-ending legal turmoil. The Paycheck Fairness Act offers no new or meaningful protections against pay discrimination. Rather, it dramatically limits the ability of employers to defend themselves against claims of discrimination based on pay disparities that result from legitimate factors. Just 2 months ago, the women's labor force participation rate hit a 33-year low, the lowest it's been since 1988. At a time when women are leaving the workforce in droves, largely due to COVID-19 and lengthy school closures, the last thing we should be doing is dragging working women through never-ending legal turmoil while making it easier for trial lawyers to score unlimited paydays. All employees should be valued for their recognizable contributions to the American workforce and economy. Instead of working on redundant laws to line the trial lawyers' pockets, this committee should be focused on policies that foster individual freedom, innovation, and pro-growth economic policies so all workers and job seekers have opportunities to achieve lifelong success. Thank you, and I yield back.
Thank you, Ranking Member Keller. Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on April 1st, 2021. I will now introduce the witnesses. Ms. Laurie Mccann is a senior attorney with AARP Foundation Litigation. Her principal responsibilities include litigation and amicus curiae participation for AARP on a broad range of age discrimination and other employment issues. McCann is a noted speaker on the aging workforce. Ms. Dina Bast is co-founder and co-president of A Better Balance, a leading national legal advocacy organization headquartered in New York City. A Better Balance is dedicated to advancing the rights of working families, promoting fairness in the workplace, and helping workers across the economic spectrum care for themselves and their families without risking their economic security. Ms. Camille Olson is a partner in the law firm Seyfarth Shaw LLP. Since 2013, Ms. Olson has served as chairperson of the United States Chamber of Commerce's Equal Employment Opportunity, EEO subcommittee. She has represented companies nationwide in all areas of litigation. Ms. Fatima Goss Graves is the president and CEO of the National Women's Law Center. Ms. Goss Graves has served in numerous roles at the National Women's Law Center for more than a decade and has a distinguished track record working across a broad set of issues central to women's lives, including income security, health and reproductive rights, education access, and workplace justice. We appreciate the witnesses for participating today, and we look forward to your testimony. Let me remind the witnesses that we have read your written statements and they will appear in full in the hearing record. Pursuant to Committee Rule 8D and committee practice, you are each asked to limit your oral presentation to a 5-minute summary of your written statement. I also remind the witnesses that pursuant to Title 18 of the U.S. Code Section 1001, it is illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress or otherwise conceal or cover up a material fact. Before you begin your testimony, please remember to unmute your microphone. During your testimony, staff will be keeping track of time and a timer will sound when the time is up. Please be attentive to the time and wrap up when your time is over and then remute your microphone. If you experience any technical difficulties during your testimony or later in the hearing, please stay connected on the platform, make sure you're muted, and use your phone to immediately call the committee's IT director whose number was provided in advance. We will let all the witnesses make their presentations before we move to member questions. When answering a question, please remember to unmute your microphone. I will first recognize Ms. McCann.
Chairs Adams and Bonamici, ranking members Fulcher and Keller, and members of the committee. On behalf of our nearly 38 million members and all older Americans, AARP thanks you for inviting us to testify concerning the need to confront workplace discrimination and the role the Protecting Older Workers Against Discrimination Act would play in doing so. For older individuals, age discrimination is the most significant barrier to both getting and staying employed. The COVID-19 pandemic has only amplified age discrimination. High and persistent unemployment, compounded by the health risks of COVID-19, threatens the retirement security of older workers, particularly women over the age of 55. A key reason age discrimination remains stubbornly persistent is because ageism in our culture remains stubbornly entrenched. Quite possibly, ageism is one of the last acceptable forms of prejudice in our society. Too often, courts fail to interpret the Age Discrimination and Employment Act as a remedial civil rights statute, which then results in its protections being weakened. Perhaps the worst example of the increasingly cramped reading of the ADEA by the court is Gross versus FDL Financial Services, a more than 10-year-old Supreme Court decision and the impetus of the Pawada legislation. Not long after the decision, I accompanied Jack Gross as he visited members of this body to encourage passage of the very same legislation we are discussing today. Mr. Gross's employer underwent a merger after he had had a successful 30-year career. Older workers who did not accept a buyout were demoted and replaced by younger workers. Jack went to court and a jury awarded him about $47,000 in lost compensation. But when his case was appealed to the Supreme Court, the court ruled that the ADEA requires a much stricter showing of causation than other forms of discrimination. It was no longer enough to prove that age was one of the motivating factors behind an employer's conduct. The court ruled that older workers must prove that age was a decisive but-for cause for the employer's actions. The Gross decision has made it far more difficult for older workers to get their day in court and even more difficult to prevail. I just explained how in Jack's own case, he won under the motivating factor framework, but after the Supreme Court changed the rules and required him to retry his case under the new higher standard, he lost, despite having proven the same facts with the same parties in the same courts as before. In another case from Jack's home state of Iowa, an older employee brought an age discrimination claim both under the ADEA and the Iowa Civil Rights Act. Under the ADEA, Gross's but-for standard governs, but under the Iowa state law, workers need only show that discrimination was a motivating factor in the adverse treatment. A single court applying the different standards to the very same set of facts reached opposite conclusions. The worker lost her ADEA case due to Gross, but her state law claim survived. The Gross decision has sent a terrible message to employers and the courts that age discrimination isn't as wrong as other forms of discrimination, that some age discrimination is okay. As long as the employer can point to other lawful motives that may have also played a role, employers will escape liability altogether. In this manner, the Gross decision undermined Congress's mandate for how they expected the ADA to be enforced, that age discrimination would play no role in employment decisions. PAWADA does not expand civil rights. It has long been a bipartisan, straightforward restoration of the standard that was in effect before 2009. Discrimination is discrimination, and PAWADA clarifies Congress's intent that no amount of unlawful discrimination in the workplace is acceptable. Congress should pass PAWADA as soon as possible. Thank you again for inviting AARP to testify.
Thank you for your testimony, and we will now hear from Ms. Baxt. Ms. Baxt, you are recognized for 5 minutes for your testimony.
Thank you to the chairs, ranking members, and distinguished members of the subcommittee for the opportunity to testify today in support of the Pregnant Workers Fairness Act and the Pump for Nursing Mothers Act. A Better Balance is a national legal advocacy organization dedicated to advancing justice so workers can care for themselves and their loved ones without risking their economic security. We founded A Better Balance 15 years ago because we recognized that a lack of fair and supportive workplace laws and policies, the care crisis, was disproportionately harming women, especially Black and Latina mothers in low-wage jobs. This bias and inflexibility often kicks in when women become pregnant and then snowballs into lasting economic disadvantage. We call this the pregnancy penalty, and since day one, A Better Balance has recognized it as a key barrier to gender equality in America. We've heard from thousands of women in both the public and private sector on our free legal helpline who have experienced the harsh blow of the pregnancy penalty. Armanda Legros, a mother on Long Island, who was forced out of her job at an armored truck company because her employer would not accommodate her lifting restriction. Without an income, she struggled to feed her newborn and her young child. As she told the Senate Help Committee in 2014, quote, "Once my baby arrived, just putting food on the table for him and my 4-year-old was a challenge. I was forced to use water in his cereal at times because I could not afford milk." Years later, we're still hearing the same stories of pregnant women who are fired or forced out instead of being granted temporary reasonable accommodations. This time, it's with a global pandemic in the backdrop that has forced millions of women to risk their health or leave the workplace, with a lack of paid leave and childcare exacerbating these challenges. At the height of the pandemic, we heard from Tasia, a pregnant retail worker in Missouri, who called us because the store's water fountain was shut down due to COVID-19 safety concerns. To avoid dehydration, which can lead to significant health consequences during pregnancy, she asked her manager if she could keep a water bottle behind the counter. He refused. Worried about the health of her pregnancy, she left her job. Sarah, a healthcare worker in Kansas, resorted to pumping milk in her car just once a day after her boss disparaged her for pumping at work. She frequently became engorged and suffered from painful clogged milk ducts. Her milk supply dropped. This took place in spite of the fact that at least 6 of her coworkers regularly took smoke breaks multiple times a day? Why, nearly 10 years later, was Tasia in the same position as Armanda? Why didn't Sarah have any recourse when she needed to pump? Why have we heard from hundreds more women in the same exact position? The answer is gaps in the law itself. Neither the Pregnancy Discrimination Act nor the Americans with Disabilities Act provide an explicit right for pregnant workers with known limitations and who need accommodations to maintain a healthy pregnancy. In our 2019 report, long overdue, we found pregnant workers are losing 2/3 of their pregnancy accommodation cases because the 2015 Supreme Court case, Young versus UPS, laid out an overly complicated, burdensome standard requiring pregnant workers to jump through legal hoops and prove discrimination to get something as simple as a water bottle. This standard is unfair and a barrier to justice, especially for Black and Latino women in low-wage, inflexible, and physically demanding jobs who need timely accommodations to protect their health and keep their paycheck. Alternatively, the Americans with Disabilities Act covers those with disabilities, but a worker with a routine pregnancy who needs an accommodation to prevent a complication is completely out of luck. The Pregnant Worker Fairness Act would finally put an end to the second-class treatment and ensure that pregnant workers have an affirmative right to workplace accommodations. I was honored to testify in this legislation in October 2019, which passed in the House this past September with overwhelming bipartisan support. In the midst of a global pandemic and SHE session, there is simply no reason for it not to pass again without delay. The 2010 break time for nursing mothers law is also falling well short due to broad exclusions and weak enforcement mechanisms. Due to where the law is placed in the Fair Labor Standards Act, nearly 9 million women of childbearing age are excluded from the law's protections. Those who are covered have no effective remedy for violations of the law. One federal judge put it best, calling the break time law's remedy, quote, toothless, and the law's incentive to terminate a breastfeeding worker rather than accommodate her, quote, an absurdity. Extensive research shows that breastfeeding has immense benefits for mothers and children, from preventing breast cancer in moms to preventing obesity and asthma in children. While most women start out breastfeeding, the numbers sharply drop as time goes on. This is often because women lack the workplace supports to continue breastfeeding. The Pump Act will change that by closing gaps in the law and finally guarantee fair treatment for nursing mothers. As Armanda told the Senate Help Committee, having a baby should not mean losing your job. It should not lead to fear and financial dire straits. In 2021, women in America should not be forced to choose between becoming a mother and earning a paycheck. Passage of these critical measures is long overdue. Thank you.
Thank you for your testimony. And next, we will hear from Ms. Olson. Ms. Olson, you are recognized for 5 minutes for your testimony.
Thank you. Good morning, subcommittee members. As an employment attorney at Seyfarth Shaw, I work with companies nationwide to ensure they maintain legally compliant employment policies and practices. I've also litigated numerous cases alleging violations of Title VII, the ADA, the ADEA, and the Equal Pay Act. My written testimony contains my analysis of the 4 pieces of legislation under consideration. Today, I will discuss a number of significant concerns with the Paycheck Fairness Act and PWADA. I will also discuss opportunities to strengthen the Equal Pay Act. First, with respect to the Paycheck Fairness Act, I'd like to share 3 of those opportunities and concerns now. HR 7 presumes all employee pay rates result from employer discrimination and rewrites existing legal standards, remedies, and class action procedures contained in the Equal Pay Act. First, HR 7 effectively eliminates the factor other than sex defense. Under the Equal Pay Act, most courts currently require an employer to prove that any pay difference is business or job related. If the employer cannot do so, the plaintiff prevails without any showing of discriminatory intent under the Equal Pay Act. Under HR 7, an employer would also be required to prove with respect to every pay differential, not only that the reason was business or job related, but also that it paid differently because of a business necessity, that the business necessity explained 100% of any pay difference, and the business necessity was not derived from a sex-based differential in compensation. Even if an employer meets these high burdens, it still loses if years later a litigant identifies an alternative employment practice that would have served the same purpose without a wage difference. But what if the alternative offered in litigation is, when implemented, less efficient, more costly, or an unproven alternative on a time-sensitive project that needed immediate staffing? Is the employer's proven business necessity now rejected? Under HR 7, the answer is yes. Similarly, HR 7 would require employers to ignore an employee's competitive job offer or salary expectation unless it can prove that the higher competitive wage offer or salary expectation is not the result of historical wage discrimination by a prior or other employer. This, by definition, is an impossible burden. Second, HR 7 goes too far by prohibiting an employer from considering prior salary information volunteered by the applicant at the outset of the application process. A majority of courts of appeals recognize justifiable reasons for considering an applicant's prior salary as a factor other than sex. Third, HR 7's expansion of available remedies and class action procedures under the Equal Pay Act is unwarranted. For example, HR 7's unlimited compensatory and punitive damages far exceed the available remedies under Title 7 and are in addition to significant penalties that already exist under the Equal Pay Act. Despite these stated concerns, there are opportunities to improve the Equal Pay Act. For example, adding language that expressly states that pay differentials between workers performing the same work must be based on business or job-related reasons, providing employees with an express protection against retaliation for engaging in reasonable activities related to a good faith belief that an unlawful wage disparity may exist, and providing employers with incentives to engage in voluntary self-critical job and compensation analyses. Moving on to one other bill before you today, PWADA, I must note it is not legislation designed to strengthen the ADEA or the rights of older workers, notwithstanding its title. Instead, it attempts to import into the ADEA, the ADA, the Rehab Act, and Title VII for retaliation purposes, the concept of mixed motive discrimination. But a mixed motive theory does not provide workers under any statute with any job-related monetary or injunctive relief. It is a remediless victory for a worker. It only provides for attorney's fees. And for all the reasons discussed in my testimony, a mixed motive theory is inappropriate to apply to these statutes or for determining retaliation under Title VII. Subcommittee members, thank you for the opportunity to share my perspective with you today.
Thank you for your testimony. And finally, we'll hear from Ms. Goss Graves. Ms. Goss Graves, you're recognized for 5 minutes for your testimony.
Thank you, Chair Bonamici, Chair Adams, Ranking Member Fulcher, Ranking Member Keller, and Chair Scott and Ranking Member Fox, and all the members of the committee for the opportunity to submit this testimony today on the Paycheck Fairness Act and the Pregnant Workers Fairness Act. I'm Fatima Goss Graves, President and CEO at the National Women's Law Center. This hearing on workplace fairness really couldn't come at a more critical time. Women, and particularly women of color, have been bearing the brunt of the pandemic and economic recession as essential workers who are risking their lives for minimum wage and too low wages, as those who have disproportionately borne the devastation of job losses, and those who are shouldering the majority of responsibility of caregiving without necessary supports. In many ways, the last year has only heightened the importance of proactive efforts to address gender wage gaps and discrimination. Workers are more desperate to keep a paycheck at any cost. They are less willing to uncover and challenge discrimination and workplace abuses, and often face retaliation for doing so. The pandemic is also likely to deepen the challenges women already faced in hiring, in promotion, in advancement. And at the same time, workers have fewer resources to formally challenge this discrimination. We know that there's a pay gap across occupations, including frontline workers. It amounts to about 10,000 per year, with even higher losses for women of color. That gap means that Latinas lose well over 1 million over their lifetime compared to white non-Hispanic men. COVID-19 also has brought home the many ways pregnant workers are already left unprotected on the job. Pregnant workers are doing essential work in frontline jobs like home health aides and nursing assistants, jobs that are physically demanding and come with even greater risk during COVID. No one should have to choose between a paycheck and a healthy pregnancy, but without a clear federal standard, many pregnant workers will continue to be denied accommodations and pushed out of work. And we've already heard today the point that discrimination is already against the law. That's of course the case, and now for 5+ decades. But the truth is, we know that the ways that our laws aren't working and allow discrimination to continue to persist. States have moved forward because Congress has not. We have 30 states in the District of Columbia have passed bills or issued executive orders to explicitly grant pregnant employees or certain categories of pregnant employees the right to reasonable accommodations at work. On equal pay, we've seen similar movement. Since 2016, we've had 14 states plus several localities prohibit employers from relying on prior salary information to set new salaries. And new research shows that these laws are working to narrow gender and racial wage gaps and increase wages for women and Black workers in particular. Multiple states have tightened legal loopholes that allowed employers to justify paying women less for equal work. In addition, pay discrimination, because it's often cloaked in secrecy and seldom obvious to the person directly affected, states and localities around the country are taking measures in recent years to bring pay practices into the light. We've had 19 states pass laws protecting employees' rights to talk about how much they make. 3 states have passed laws requiring businesses to provide salary information to applicants during the hiring process, and states, including California and New Jersey, have enacted pay data reporting requirements. Globally, we've seen movement too. In Europe, we've seen legislation require analysis and reporting of compensation data and public disclosure of wage gaps. And research shows the positive effects of these mandates on driving employer pay analyses and closing wage gaps. So, but it's not enough for states to pass laws, and it's not enough for global corporations to feel indirect pressure to address their US pay practices because of other countries like the UK. And it's also not enough for some employers to voluntarily take steps to close the wage gaps, although we have been heartened to see that happen. This country deserves robust baseline protections in our federal law that actually work. So the Paycheck Fairness Act is definitely part of this response. When it bars retaliation against workers who talk about pay and requires employers to report pay data, that's promoting both transparency and compliance. When it prohibits employers from relying on salary history to set new pay, it prevents pay discrimination from following people from job to job. When it closed the loopholes in the law, it actually ensures that our pay discrimination laws work, and it ensures women can receive the same robust remedies for sex-based pay discrimination. We just believe we can't build back an economy that works for everyone without ensuring all women can work with equality, safety, and dignity. Thank you for the opportunity to testify, and my full written testimony submitted for the record. I look forward to any questions.
Thank you for your testimony. Under Committee Rule 9A, we will now question witnesses under the 5-minute rule. After the chairs and ranking members, I will recognize members of both subcommittees in the order of their seniority on the full committee. Again, to make sure that the members' 5-minute rule is adhered to, the staff will be keeping track of time and the timer will sound when the time has expired. Please be attentive to the time and wrap up when your time is over, and then remute your microphone. And as chair, I recognize myself for 5 minutes. We have discussed how reasonable accommodations do not need to be, nor are they typically complicated or costly. But when pregnant workers do not have access to the accommodations they need, they are forced to choose between their financial security and their pregnancy, and the results can be devastating. Ms. Bast, can you describe which pregnant workers are most negatively affected by the lack of a reasonable accommodation?
Absolutely, thank you. So the pregnant workers who are most negatively affected are women in low wage, inflexible, and physically demanding jobs disproportionately Black and Latina women who work in both the private and state employers. Many low-income workers can't work from home. Millions remain in the workforce, with women of color disproportionately represented in frontline, often low-wage jobs such as fast food, retail, home health, and state police officers, where they continue to face structural biases that prevent them from caring for themselves and their loved ones and maintaining their economic security. When a low-income pregnant worker loses her income, she doesn't have access to job-protected leave, too often doesn't have access to fall back on, so she spirals into deeper economic trouble with lasting economic and health consequences. We've seen workers who've lost their health insurance, forcing them to delay or avoid critical pre or postnatal care, or leaving them with crippling medical bills. Others like Armanda struggling to feed their families, or others wind up homeless. Prospects of promotion, advancement, and retirement savings also disappear, especially as it becomes more difficult to re-enter the workforce after becoming a mother, exacerbating the gender wage gap, and many mothers falling deeper into poverty. Preserving pregnant workers' economic security is especially important at a time when the COVID-19 pandemic has disproportionately, again, harmed women of color and low-wage jobs, with many experts suggesting that it could take years to undo the economic damage. And many will experience long-term hits to their careers, earnings, and retirement security. While the PWFA was needed before the pandemic, it has taken on a new urgency as a critical measure to keep women healthy and attached to the workforce.
Thank you, Ms. Baston. I know you mentioned a bit in your oral testimony, but can you briefly talk about what kind of health complications can arise when pregnant workers don't have a reasonable accommodation? And I do want to allow time for another question, so if you could be brief, thanks.
Sure. Look, pregnancy accommodations are a crucial tool to address our nation's maternal and infant health crisis, right? I'll never forget a pregnant cashier who fainted and collapsed on the retail floor due to dehydration because her employer wouldn't let her carry a water bottle. Our former client, Tasha Morrell in Tennessee, was forced to continue heavy lifting while pregnant and working at a factory and wound up miscarrying. And just this past year, one court held that a pregnant worker with complications, including preeclampsia, was unprotected and not entitled to accommodations because she didn't have a disability. This is absurd. These accommodations are low cost, often, with lower no cost, but with high impact, helping to prevent miscarriage, preterm birth, low birth weight, preeclampsia birth defects, and the racial disparities in maternal health outcomes are truly staggering.
Thank you so much. And I'm going to have to move on. And I do know that my home state of Oregon has passed at the state level similar legislation, which was broadly supported, including by the business community, because it's giving them certainty about what they need to do to accommodate pregnant workers. So my home state of Oregon has one of the most rapidly aging populations in the country. And I've heard from workers, particularly in the technology industry, who have been dismissed or denied employment because of their age. But investigations by the U.S. Equal Employment Opportunity Commission often take years to complete, and age discrimination is, as we heard in the testimony, often very challenging to prove. So Ms. McCann, can you explain how the change in the standard of proof in the 2009 Gross decision, and I note that Mr. Jack Gross was with us when we had a hearing on this in the last Congress, how has that adversely affected age discrimination in employment claims? And are ADEA claims more difficult to prove after the Gross decision? And if so, how? And there's not a lot of time left. If you could be brief, please.
Sure. So I think there's three ways that it's negatively impacted age claims. One, as I said, it sends a message to the courts that age discrimination is not as wrong. And that translates into bad decisions. In the mixed motive framework, and once the age discrimination plaintiff is able to prove that their age did motivate the employer's action, they cannot prevail unless they are also able to prove that another factor did not influence the adverse decision, which is an almost impossible task for the older worker.
And Ms. McCann, I'm sorry, but I have to set a good example and cut myself off because I'm out of time, but I look forward to continuing the conversation. I'm sure you'll get other questions.
Okay.
And I now recognize Ranking Member Fulcher for the purpose of questioning the witnesses for 5 minutes.
Thank you, Madam Chair. I got a question for Ms. Olson, if I may. I just want to touch on what I think could be a significant real world application here. So Ms. Olson, thank you for your testimony. when Congress considers a piece of legislation, I believe we should be absolutely clear about how the legislation would affect the American people. And when it comes to protecting older workers against Discrimination Act, my experience tells me that most workers filing lawsuits, even if successful, will not likely recover any damages, but attorneys and their attorneys will be awarded costs and fees. Is that your sense with this?
Thank you for your question. And the answer is yes. It's not just my sense, and it's not just the majority. No worker under a mixed motive theory, whether it's brought under Title VII, the Age Discrimination and Employment Act, or any other act, receives any monetary remedy. That is why you don't see many of the mixed motive cases ever brought. So to amend the Age Discrimination and Employment Act or any of the other acts that are at issue here with the language from POATA is going to do nothing to help workers. That's true today. That's true today under Title VII in terms of mixed motive. That's available for certain types of causes of action. And that would be true tomorrow with respect to older workers. And if I just might note, if you look after the Gross decision in 2009, 10 years after it, the average percentage of EEOC charges that are age charges, 21%. The 10 years prior to Gross, it was 22%, virtually the same. Since Gross, I've counted at least 22 different Court of Appeals decisions that have granted summary judgment under the Gross standard for plaintiffs or reversed summary judgment for a defendant, saying the ultimate question of whether the plaintiff's termination was a result of age must go to a jury. So I don't see the need and I don't see the benefit, most importantly, under POATA for a mixed motive theory in either the Age Act or any other statutes that's considered under POATA.
Ms. Olson, thank you for that. You mentioned mixed motive claims. And so my next question is kind of two-stage, but it brings that in. In 2013, the Supreme Court ruled that mixed motive claims are not allowed in Title VII retaliation cases. And retaliation cases are especially ill-suited to include mixed motive claims. So from a policy perspective, could you explain if and why the court's 2013 decision was sensible? And also, this is the second part of the question, based on your experience as a litigator, what concerns would you have in allowing mixed motive claims in these retaliation cases?
Thanks for your question. The concern I have is limitless, never-ending litigation that's going to go beyond summary judgment, but will not result in an award for anybody in terms of a worker alleging retaliation. In terms of why it's not suited, why mixed motive isn't suited for a retaliation claim, it's because the mixed motive says if retaliation or an element of retaliation, such as the engaging in a protected activity, is 1%, it's in the room, it's in the air, it's relevant, it was close in time, the protected activity that was engaged in, that becomes part of a potential motive for a jury to determine, even if everybody agrees that the reason the employer took the action was not for a retaliatory basis. Even so, even if everyone agrees that the reason was a good reason, it was not retaliation, the fact that the prima facie case in a retaliation claim includes the fact that the plaintiff engaged in a protected activity sometime close in time, that leads you to a potential jury verdict and a potential result that, again, is not going to benefit the worker because they get no monetary damages, they get no employment injunctive relief for themselves, even if their lawyers win that case.
Okay, Ms. Olson, just thank you for that. I could do about 10 more questions, but thank you for your answers. I've run out of my time. You were very clear on this, and I greatly appreciate your testimony. Madam Chair, I yield back.
Thank you, Ranking Member Fulcher. I next recognize Chair Adams for 5 minutes for your questions.
Thank you, Madam Chair, and thank you to all the witnesses for your testimony. Ms. Ghost Graves, the Paycheck Fairness Act clarifies that if an employer justifies pay disparity based on a factor other than sex, such defense must be based on a bona fide job-related factor such as education, training, or experience that is consistent with business necessity. So can you give us examples of how this business defense has historically been applied in ways that perpetuate gender-based wage discrimination?
Sure. The first thing I just want to remind everyone is that there are already defenses embedded in the Equal Pay Act that go beyond the factor of sex. So we're not talking about things like experience or education or different specific skills. Those are listed out specifically. What we're talking about is the factor other than sex. And there, what we have seen is some employers point to vague notions of the market or the ability to negotiate more, even though there's all of this research that shows that women are often penalized when they negotiate. They're considered to be too mean or bossy when they engage in behavior that's considered typically male behavior. Or sometimes people just point to the fact that men make more in the market. And so what the factor other than sex defense would do is tighten the number of reasons and justifications for paying people who are basically doing the same thing, different salaries.
So Ms. Olson claims that HR 7 pushes the EPA to heights that would essentially obliterate the other factor, the factor other than sex affirmative defense out of the statute. Is this the case?
It certainly does not, but it does actually require a legitimate business justification and require that be tested. It's not enough for an employer to just say, here's a business justification. It's important for that justification to be tested so that you don't have someone doing something that basically is a proxy for sex discrimination. Otherwise, the factor other than sex would continue to be such a large loophole, it swallows the whole requirement that you pay people equal wages for doing equal jobs.
Thank you. Ms. Bask, I've heard some concerning reports of workers who are currently eligible for breastfeeding protections being denied accommodations during the pandemic. Why are workplace accommodations for nursing mothers to pump breast milk even more important now during the pandemic as workplaces reopen? So
Sorry about that.
Oh, that's all right. Go ahead.
That's right. At A Better Balance, we've also heard concerning reports as well, where the pandemic seems to be used as an excuse by some employers to dodge their legal responsibilities to breastfeeding employees, even when providing break time and space is no harder than it was before. It is essential that employers follow the law and provide break time and space to their breastfeeding employees during the pandemic. Because hundreds of thousands of women have left the workforce as a result of caregiving responsibilities and pregnancy discrimination, providing support for new mothers is critical to helping women get back into the workplace. The pandemic has laid bare these systemic barriers that prevent women from staying in the workplace and thriving. Break time and space are part of a broader range of solutions we need to support mothers so they can work and care for their families without risking their economic security.
Thank you, ma'am. Madam Chair, you're back.
Thank you, Chair Adams. And I next recognize Ranking Member Keller for 5 minutes for your question.
Thank you, Madam Chair. Ms. Olson, I want to thank you and all the other witnesses for your testimony. But under HR 7, to defend against a claim of pay discrimination, an employer must show the pay differential is a business necessity. Even after showing this, the employer defense does not apply if the plaintiff can demonstrate an alternative business practice would not result in a pay differential. Do you agree the business necessity requirement in HR 7 is unworkable and makes it nearly impossible for a business owner to defend against a pay discrimination claim?
Unequivocally, it does make it impossible. It is unworkable, and I really have to correct the record from the last couple of questions and answers. Business necessity is not currently part of the Equal Pay Act. And in addition, experience and special skills are not enumerated factors in the Equal Pay Act, notwithstanding what's been said in this hearing. The only factors that are enumerated are seniority, merit, and productivity, and other factors similar to those other than sex.
Thank you. I appreciate that. Also, you state in your testimony, Ms. Olson, employers of all sizes need clear guidance and predictable outcomes when applying the law to their employment policies and practices. In your view, does HR 7 provide clear guidance and predictability?
It absolutely does not. And I would tell you that if you look at my testimony, which is quite detailed, but I included 9 different examples on pages 9 through 14 of specific real life cases where an employer could not show business necessity. Ms. Graves just mentioned that the business is required to test. So if a business determines that it is going to pay more for an applicant because of their years of experience or their seniority at another employer, which they believe is relevant to the job, how is that tested? Business necessity has never been part of the Equal Pay Act. Job related and business related has always been part of the factors other than sex, as all of the Court of Appeals that I've cited in my testimony have noted, and that is how employers are in fact understanding the Equal Pay Act and applying their pay practices. What is business related? That employers know. What is a business necessity? It's not defined. It's not been defined by any witness here. It's not defined by any court cases. And as I described in my testimony, does that mean the business can't live without it? How does an employer show when an applicant says, I won't become employed unless my pay is $1 more an hour because I've got 5 more years of experience or I've got more education than someone? Those are factors that fall under the factors other than sex affirmative defense. How does an employer show that's a business necessity? And even if they can, they lose if later on in litigation, a litigant says, but you could have made up the difference by just increasing everybody's pay. What the Paycheck Fairness does in terms of business necessity and the other unworkable changes to the Equal Pay Act is it disadvantages all workers who have higher qualifications and seek, and employers believe justifiably have qualifications that relate to their business and the jobs and want to pay them for that.
Thank you. That answered actually the questions I had regarding experience and other business related factors, education, productivity, job skills. But I have another question, Ms. Olson. HR 7 provides for unlimited compensatory and punitive damages, and it also expands class action lawsuits for pay discrimination claims. Will these provisions address pay discrimination in the workplace, or will they merely encourage costly litigation that will benefit trial lawyers?
There's no question that changing the class action procedure under the current Equal Pay Act from a collective action to a Rule 23 class action will slow recoveries, will slow the course of litigation, will not allow the litigants to actually focus on, and the difference is currently under the Equal Pay Act, if a collective action is brought, which is the class action procedure, the court sends out a notice to all potential workers and says, do you want to be part of this? And if so, just send back in a form. Anybody who sends back in a form then is part of it, and you focus on that group of individuals to determine whether the case will be settled or it will be litigated, but on real facts. In a Rule 23 class action, it is my day-to-day experience that employers spend hundreds of thousands of dollars, if not millions of dollars, on class certification procedural arguments that take years to be resolved before anyone ever gets a resolution. And in terms of unlimited compensatory and punitive damages, remember, the Equal Pay Act is a strict liability. You don't have to prove intentional discrimination. It already allows double damages. It allows plaintiffs to go back 3 years if willful, as opposed to 300 days for a charge of discrimination under Title VII. These damages are greater and different than any other damages we see in any discrimination law and are unnecessary under the Equal Pay Act.
Thank you. I appreciate that, and I yield back.
Thank you, Ranking Member Keller. And next, we have the chairman of the full Committee on Education and Labor, Mr. Scott from Virginia. You're recognized for 5 minutes for your questions.
Thank you. First, I'd like to ask Ms. Goss Graves. We've heard a lot of confusing things about the Paycheck Fairness Act. Can you tell me what the differences are in recovery now and what the differences in recovery and process would be if the bill would pass?
Right now, under the Equal Pay Act, you are allowed to get back pay for 2 years. And in particular types of conduct, sometimes that amount can be doubled. If you're talking about a low wage worker, what that means effectively is that the amount that they can recover under the Equal Pay Act might not actually cover their actual costs from experiencing pay discrimination. Under Title VII of the Civil Rights Act, damages have been capped and not adjusted at any point of time in over 3 decades. And so what that actually means is that if someone is bringing a pay discrimination claim, their damages are arbitrarily limited. They don't actually match what they have experienced.
And how does the Paycheck Fairness Act fix that?
So what the Paycheck Fairness Act would do is allow people to recover the full amount of their damages, the full amount that they are injured. And so I just wanted to correct one thing. The use of the term unlimited doesn't actually apply. The limit is actually your injury. So it is never unlimited.
And how is that compared to other forms of discrimination?
Well, one of the differences is that if you were bringing a race-based claim, there's an alternative outside of the Civil Rights Act by being able to bring a claim under Section 1981. And so right now, there's this weird conundrum where for sex-based pay discrimination claims, you have this sort of limit. You don't have a current similar vehicle similar to 1981.
What's wrong with asking about salary history?
So here's the thing about salary history. The reason it's less about asking, but it's really how you're going to use it, right? The reason that employers want to ask about salary history is because they want to match salaries. If you were making $100,000 in your last job, you should make $100,000 in your next job. But the truth of the matter is, we know that women start off making less from the earliest points in their career. So setting your new salary on the salary you might have made at the last job is a way to guarantee that you never get out of this cycle of making unfair pay.
And we've heard about the employer having to prove that once you've shown the difference in salary, the employer has to prove that there is a non-gender related reason for the differential. Seems to me the employee can't possibly know what's wrong with requiring the employer to show, after you've shown the difference, the employer is the only one that knows why there's the difference.
I mean, basically, all of the salary information lies in the hands, really, of the employer. The employer knows why they're paying people doing the same thing different wages. What you want to do is put the incentive so that the employer pays people correctly the first time. That's what we're trying to incentivize here. And I just wanted to correct one thing because I don't want to confuse the committee, and I'm happy to give a longer written response. And that is, so currently under the Equal Pay Act, you are right at seniority. I was using experience as a shorthand. The Paycheck Fairness Act makes very clear as examples around education, experience, and skill. I have yet to hear the example that is not an example that you wouldn't want to test and probe further for paying people doing the same thing different wages. And these ideas from employers really do have to be tested in some way.
Thank you. Ms. McCain, have you heard anything about the quota that you wanted to respond to?
Yes, thank you. I think Ms. Olson's testimony ignores three important facts. One, that Congress has determined that any amount of discrimination is too much, and that the goal of civil rights protections is not more litigation, it's less discrimination. And although she makes a lot of the fact that in a mixed motive case, the victim does not receive back pay or reinstatement, she ignores the fact that the injunctive relief and declaratory relief that is available to a successful mixed motive plaintiff goes a long way in deterring future violations, and that there are two goals to every civil rights statute. One is compensation, but the other is deterring future violations. And what Pallada recognizes is that no age discrimination, no amount of discrimination should be tolerated. Thank you for the opportunity.
Thank you. You're back.
Thank you, Mr. Chairman. Next, we're going to recognize Mr. Thompson from Pennsylvania for 5 minutes for your questions.
Chairwoman, thank you very much. Thank you, Ms. Olson, for being here today to discuss these issues. I would say it would have been nice to see a more balance of witnesses. Just for the record, I agree with Ranking Member Keller on that. If we're going to pursue bipartisan solutions, we need to have everybody at the table. But thank you, Ms. Olson, for being here today to discuss these important issues. As you know, 2 federal laws currently prohibit discrimination in wages and the terms and conditions of employment based on sex. Thus, equal pay for equal work is already required by federal law. Now, I was reading your testimony. You mentioned how much time and effort businesses put into determining their workers' various pay levels, which they must do to recruit and retain high quality workers. That's always that's the responsibility, the duty of the employer. So my first question, in your experience, does it help a business succeed and thrive to pay a worker more or less depending on their gender?
It hurts everyone. And that's why employers, in my experience, not only don't do that, the vast majority don't, but they have a deep commitment to ensuring that all workers are paid appropriately with respect to job and business related factors that relate to the work that they are doing. There's absolutely no benefit. What are some of the deterrents to doing it besides litigation? Motivating your employees, ensuring that you have retention of your workers, and ensuring that the morale of workers who work together in teams more than they ever did, whether it's virtually or side by side, are able to do so productively and in a way that fosters usually a joint or team effort. So there's absolutely no motivation to doing so, and there would be no reason to do so.
So you've really touched on with your response also identifying the importance of offering appropriate compensation to all employees, right? To be able to have that not just qualified and trained, but reliable workforce.
Yes, that's absolutely correct, Congressman. Without doing that, this is a very mobile workforce. People move from job to job more than they ever did in the history of the American workplace. And today, employers spend an enormous amount of effort to not just conduct pay audits, but to also review starting pay decisions and the impact of a hot job market on existing long-term employees to make sure that there aren't inconsistencies that perhaps should be addressed. Things that are differences in pay based on business or job-related factors, but nevertheless, employers are saying, I want to make sure that we've got that. They're also doing a lot on the information gap. A lot of the issue here relates to how do we capture, digitize, memorialize pay decisions and factors to make sure they can be identified and explained. The Paycheck Fairness Act goes far beyond that, What it does is it says, I want you to test every reason. I want you to tell me and prove that you had to pay that worker more for that extra experience, that you had to pay that worker more for that extra education or for the seniority at another employer, or that you had to hire that employee because they told you they wouldn't take the job unless they were paid more than what you were offering. And you've got to show that's a business necessity. You've got to not only show that, but you've got to show that you didn't have the ability to perhaps raise everybody's wages to that level. How does an employer do that and compete in the marketplace for workers? It can't. You know, you heard some of the other witnesses today talk about employers need to test. How do you test when an applicant comes to you and says, I understand you're offering, let's just say, $50,000 a year for this position, but my qualifications are higher. I'm making more today, and I have this special expertise. How does an employer test that meets a business necessity standard to pay that worker more than somebody who's a current employee? What's going to happen? That worker's not going to get the extra pay offered to them. Everyone's going to suffer.
Well, thank you, Ms. Olson. You're really focused on, I think, what the motivation and incentives for employers really to compensate their employees well and how important that is. So thank you very much, Madam Chair. I yield back.
Thank you, Ms. Thompson. I next recognize Representative Hayes from Connecticut for 5 minutes for your questions.
Thank you, Madam Chair, and thank you for holding this very important hearing today. Madam Chair, I'd like to submit a document from the Equal Rights Advocates in support of the Paycheck Fairness Act for the record.
Without objection.
Thank you. My questions today really speak to the Pregnant Workers Fairness Act. I've spoken at other hearings before about my time in the classroom during my pregnancy, where I needed unscheduled bathroom breaks, which seems like a reasonable accommodation. But when you are in a building and you need another teacher or another faculty member to come and relieve you so that you can go to the bathroom, it becomes an unnecessary hardship. I've seen so many of my colleagues in the profession suffer with urinary tract infections or long-term urinary retention problems and other complications caused by what seems like just an accommodation that people can reasonably, that employers can reasonably make. So this is something that we all have to be intentional about and make sure that we are working to promote those kinds of practices, because when you're in a building with 1,400 kids, it's not very easy to just walk out of your assigned post or your classroom to use the bathroom. My questions today are for Ms. Bass. You know, women across the country still face the impossible choice: risk your paycheck or your employment. You shouldn't have to take time off from work just because you need to be able to use the bathroom. So Ms. Bass, can you provide us with the economic consequences experienced by employees when they are denied a reasonable accommodation or perhaps pushed out of a job prematurely because those accommodations cannot be met?
Sorry, yes, certainly. So, you know, it's truly hard to believe that in 2021 that, you know, pregnant workers are routinely still being denied bathroom breaks and water bottles and are forced to choose between maintaining a healthy pregnancy and earning a paycheck. And what we've seen over and over and over again are the profound health and economic consequences of this decision. It seems so simple. Oh, it's just, you know, this discrete period of time. It's not. It spirals. It snowballs into lasting, devastating economic consequences for women. It pushes too many women deeper into poverty because they are losing their paychecks at a moment that they, you know, so many women, when they get pushed out, they say, I tried to reapply for a job. Who is going to hire me? Then, you know, they're a new mother and they've been detached from the workforce, and finding a job is incredibly, you know, they face heightened challenges. And so these economic consequences force them to really risk their ability to support their families, put a roof over their head, put food on the table, have adequate supports that they need, and all because they simply needed to maintain their health during their pregnancy. And it's unacceptable. And as you said, we've worked in almost 30 states. These laws, similar laws are on the book in 30 states. It's been recognized as, a no-brainer, essentially, as this modest accommodation can go such a long way to help women stay healthy and attached to the workforce.
Thank you. I've heard similar stories about that from women across my state. In one incident, we had a firefighter who was placed on an unrequested unpaid leave because of her pregnancy. Despite she wanted to work. She tried to make suggestions and try to work with the employer, and she was just denied and placed on an unrequested leave. Also in my district back in 2008, we had 6 low-wage Black women who were working in a warehouse that suffered a miscarriage, despite asking for reasonable accommodations and providing the required documentation from their medical provider. So these cases demonstrate for me that the current law is not sufficient to protect pregnant workers from harm. Ms. Bass, can you help us to understand why bringing a pregnancy-related reasonable accommodation claim under the Americans with Disabilities Act's existing legal standard is insufficient for preventing pregnancy discrimination?
Absolutely. Sorry. Absolutely. So there are 2 main problems with the Americans with Disabilities Act. This is an important law that guarantees reasonable accommodations for workers with disabilities. The problems here are, first of all, pregnancy is not recognized as a disability under the Americans with Disabilities Act. So for pregnant workers who are not disabled yet, right, who have a pregnancy-related health need to prevent complications, they're forced out. They have no luck. And the second is most pregnancy-related complications are not recognized as ADA eligible accommodations, preeclampsia, high-risk pregnancy.
I'm sorry, I want to continue, but it looks like my time is run out, but you said something that from your words to God, from your mouth to God's ears, pregnancy is not a disability. With that, Madam Chair, I yield back.
Thank you, Representative. And if Ms. Bass could submit the rest of the answer to in writing, or unless somebody asks. Next, we're going to go to Representative Stefanik from New York. You're recognized for 5 minutes for your questions.
Thank you, Chairwoman. Ms. Olson, you suggest providing employers incentives to engage in voluntary self-evaluations to proactively identify and address any pay disparities attributed to the sex of employees. How widespread are compensation self-evaluations, and are there reasons they are not more prevalent?
Thank you for your question. They are becoming more widespread. They are not prevalent, Congresswoman Stefanik. And one of the deterrents that employers have to engaging in them is the uncertain status that self-critical analyses have under the law in terms of discoverability. And that's one of the problems, and that's one of the issues. And so, yes, more and more employers engage in these audits. These audits are usually ones that require statisticians, outside consultants to assist in analyzing not just pay, but also the jobs and whether the job should be compared, and then identifying relevant factors.
Well, let me ask you this. Let's look at a state that does have that at the state level. Massachusetts law encourages proactive self-evaluations by providing employers a safe harbor if they conduct good faith evaluations and take concrete steps to eliminate any pay disparities. Do you believe that expanding this model will lead employers across the country to use self-evaluation and improve their compensation practices?
The answer is simple and straightforward. Yes, it definitely will, and I can speak from experience in working with employers. Those that do it and would have a lot more certainty and would do it even more robustly if they had that certainty in terms of the audits and that proactive additional reason to do them, and those that aren't doing them now or aren't doing them as frequently would do them more often. There is no question about that, because the benefit would be so clear, and the outlines of any risks or not having a risk of doing the audit in terms of privilege would be right in front of them, and they could weigh it clearly and move forward with the audit. So absolutely.
My next question is on strengthening the existing prohibition on sex-based discrimination. You made several recommendations to improve current law under the Equal Pay Act. One of those recommendations is to add a clear requirement that a pay differential must be business related, which is consistent with the majority of U.S. Circuit Courts of Appeals have held. How would this change strengthen the Equal Pay Act and provide predictability and clarity for employers and workers?
It would strengthen the Equal Pay Act and provide clarity by being written into the statute. As I said in my testimony, the majority of courts of appeals, but not all, already attach that requirement to the statutory language factor other than sex. This would make it universal. It would make it so that this would not be something that people were litigating over, and this would provide clear definition, because a factor other than sex that is job or business related is something that is a standard that employers clearly can understand and use. Business necessity isn't.
And then I want to ask about the wage history issue, which is important. In your testimony, you discuss various scenarios where HR 7's outright prohibition on considering a prospective employer's prior salary can actually function to disadvantage job applicants, including women. Do these same concerns exist if prospective employees are empowered to share their prior salary at any point during the hiring process, and employers are permitted to act on this information when voluntarily provided?
So that's a great question. So the answer is it depends. If the Equal Pay Act is not amended to include business necessity, then an employer can act on a voluntarily shared job expectation or wage expectation without concern. But if that were appropriate under the Equal Pay Act as amended, but the employer still had to show business necessity, and that it was not just a business necessity, but it was also the least impactful in terms of the opposite sex, I'm not sure that job expectations of an applicant can ever be considered at any stage of the process as the Paycheck Fairness Act is written. Without business necessity, yes, it absolutely can be.
Thank you, Ms. Olson. My time's expired. Yield back.
Thank you. And I now recognize Representative Stevens from Michigan for 5 minutes for your question.
Thank you so much. And thank you for this important hearing. There are about 4.2 million women between the ages of 19 and 25 who are covered as dependents on a parent's employer-sponsored health plan. And my understanding is that insurance companies in the large group market and self-insured employer plans are currently exempt from federal requirements that guarantee dependents have coverage of crucial health services such as labor, delivery, and maternity care. Ms. Goss-Graves, do you think you could explain this loophole and how it relates to the intersection between the Affordable Care Act and the Pregnancy Discrimination Act?
You know, when you were right that there is this terrible loophole, when a non-spouse dependent is denied maternity coverage on an employee's health plan, that has been held not to violate the Pregnancy Discrimination Act because, as the theory goes, it represents sex discrimination against the dependent, not against the employee. And the Pregnancy Discrimination Act only protects employees from sex discrimination. It doesn't protect their dependents. And so you're correct that insurance companies, both in the large group market and who are self-insured employer plans, are exempt from covering maternity care as an essential benefit, but they may be required to provide dependent maternity coverage under Section 1557 of the Affordable Care Act, which bans discrimination in healthcare programs and activities that receive federal funds. So that is for some piece that might be, but through a range of legislation that has attempted to address this loophole on dependent coverage, and the gap is not acceptable for sure.
Yeah, and then let's also just give you an opportunity, if you don't mind, to respond to some of the claims that Ms. Olson has made regarding the Paycheck Fairness Act. For you, Ms. Gosgraves.
Well, I'd like to remind people that pay is one of those things that is cloaked in a lot of secrecy, where all of the information nearly is lying with the employer. And employees typically don't have a reason for knowing that they are making less at all, or certainly why they're making less. And so employers have all the information in addition to having the decision-making power. So while I totally agree that the incentive should be that they want to pay people right the first time and pay equally, there is lots of business case reasons for doing so. They just don't always do it. And I wanted to give, just if I have a minute, to give a couple more examples of the types of things we see in factor other than sex that we are worried about. You know, you might have an employer arguing that they're paying someone more because they have potential, or because they see something in that man, or something else that is vague and not specific. Those are the types of things that you really want to be sure are vetted and don't become just another proxy for sex. And there's a reason that the Paycheck Fairness Act lists very specifically things like education and experience, because those are typical things that are totally fine to pay different wages for, as long as they are actually themselves aren't sex-based reasons. So if you don't usually pay differently for experience, you shouldn't, just because you're now in a certain situation dealing with a woman and you want to pay her. That, you know, that's the only additional type of vetting that would be important.
Great. Thank you. And Madam Chair, I'd also like to enter to the record a letter from the Network Lobby for Catholic Social Justice in support of the Pregnant Workers Fairness Act.
Without objection.
Thank you. And with 1 minute remaining, Ms. Bass, I just wanted to quickly ask you why pregnant workers have struggled to get accommodations under the ADA.
Yeah, again, I mean, it's just pregnancy is not a disability, and pregnancy related, the ADA was expanded in 2008, the Americans with Disabilities Amendment Act, and there was a lot of, hope that more pregnant workers with complications would be covered under that law. And, many have been covered under that law, but too many have been left out because courts are saying your complications are not serious enough to warrant accommodation. So, I mean, crazy hypos that are in court cases that women with severe bleeding, all sorts of health conditions, and courts are saying, sorry, you don't qualify for ADA coverage, and that's absurd.
Thank you so much, and I yield back. Thanks, Madam Chair.
Thank you. I next recognize Representative Miller Meeks from Iowa for 5 minutes for your questions.
Am I unmuted? Thank you so much, Madam Chairwoman. Thank all the panelists for being here. Ms. Olson, my question is directed to you from my own personal experience. I'm currently a physician, but I've had, numerous jobs as I paid myself through nursing school, my master's in education, collaborating that with the military. Had 2 pregnancies, very healthy pregnancies, thank goodness, which I did, one during an internship, one during a residency, breastfed and pumped for both of those children up until about 18 months. And so in medicine, there are differences in pay scale. This has been brought up before between women and men, but when you look at the factors, it's specialty, hours, and leave. And so my question is, there was a Harvard University scholars published in 2018, a study on bus and train operators working for the Massachusetts Bay Transportation Authority. And I think this was alluded to earlier. All the employees in the study were covered by the same collective bargaining agreements, working under the same seniority system. The study found that this caused male operators, the wage difference, of 11 cents gap was found by male operators taking fewer unpaid hours and choosing to work more overtime. And if you can say, in your experience working with issues related on compensation, are the Harvard studies findings relevant to the debate on HR 7?
Thank you for your question. And what I would say to that is, there's no question that certain job-related factors that relate specifically to experience and expertise, and some of the other factors that were discussed today are related to differences in pay, and that those are factors that are considered because they're job or business related. Other factors that aren't job or business related are not currently allowed under the Equal Pay Act and would not be and should not be part of compensation systems, and in my experience, they are not.
And how would HR 7, how would that impact like bonuses or recruitment bonuses, or recruiting and hiring somebody from another company? If these stipulations are in place, and paying somebody a higher wage, if each time that you're looking at bringing an employee on or giving a bonus, you have to look at all these other factors and wages.
Yeah, the difficulty with HR 7 is it basically says, look at the job they're hired to do, pay everyone the same. Because if you differentiate based on higher or better qualifications or experience or education or something special about their background, or the fact that they tell you they will not come to your employment unless you pay them more than what you've originally offered in your starting pay, you're not going to be able to prove that that was a business necessity.
Thank you so much.
And courts don't serve as super personnel departments to second guess every employer's decision with respect to pay. So if I'm an employer, what am I going to do? Am I going to give bonuses? Am I going to pay people differently? If I do so, I'm just going to let myself open to endless litigation at whose detriment? Those employees who actually have special skills, who actually have special expertise, who bring something extra that is worth paying for.
Okay. And to that end, HR 7 directs the Department of Labor's Office of Federal Contract Compliance Programs to implement a survey of all non-construction federal contractors to collect pay data and other employment-related data, including hiring, termination, and promotion data. And given our previous question, should we also not have data on leave, unpaid or paid, family leave, hours worked overtime, loan repayment, length of service, seniority? And you can feel free to answer that. And if there's time, Ms. Goss, would love to have your input also. And with that, I'll yield my time after you've answered. Thank you so much.
I would just say very quickly that the kind of data that's being requested goes far beyond any of the, under HR 7, goes far beyond the Equal Pay Act and its specific goals. It also is data that employers don't currently collect. Promotion data, data of national origin. And in terms of your question, to be able to really understand what are making the differences in pay. Are they legitimate, business-related or job-related factors? You can't really get that in the kind of two-page form that the government's talking about implementing in HR 7. It would be useless, it would have no utility. And that's what the EEOC found when it collected the 2017 and 2018 EEO1 Component 2 data.
The time has expired, so I'm going to go next to Representative Legia Fernandez for 5 minutes for your questions.
Thank you, Chairs Bonamici and Adams, and thank you to the witnesses for joining us today. You know, we're here today to talk about fairness, or perhaps we should say a lack of fairness. And, you know, it strikes me that the testimony provided what legislators, what, lawmakers must hear, which is how has the existing law failed to achieve its goals, and how can we fix those gaps, right? That's our job. And I must admit the examples provided by the witnesses are compelling, and the data is compelling. Women carried the brunt of job losses during the pandemic, losing a net 5.4 million jobs. And we need to make it easier for women to get back to work, including pregnant women. I liked the point that was made earlier that states are moving in the right direction, including my state of New Mexico, which passed the Pregnant Woman Accommodation Act with bipartisan support last year. But all women in every state must have similar protections. So Ms. Baxt, explain again how the Pregnant Workers Fairness Act will ensure that Latina women especially don't have to choose between their health and job security.
Yeah, Thank you for the question. And as I pointed out earlier, this issue disproportionately impacts women of color and Latina women especially, right? And, we heard earlier that the wage gap for Latina women is, the most pronounced of any of the wage gaps that we had heard earlier. And part of that, I believe, has to do with there are many reasons for the wage gap, but discrimination is part of that. And when pregnant women are pushed off the job because they have to be forced to choose between following doctor's orders or protecting their health and risking their jobs, they are going to suffer profound health, and economic consequences. Latina women are often, the types of jobs they're congregated are often put them in that position, right? These are jobs that are often less safe, more physically demanding. And so the nature of those jobs require an affirmative accommodation protection to help them protect their paycheck and maintain their health.
So in some senses, these are the essential workers that we're giving lots of thanks to these days. And what we're asking in this law is to give more than thanks, but actually respect and accommodation. Chair Bonamici, I'd ask unanimous consent to submit 2 items into the record. The first is a letter from the National Partnership for Women and Families in support of all of the bills before us. The second is testimony from Physicians for Reproductive Health in support of the Pregnant Workers Fairness Act.
Without objection.
Okay, so for every dollar paid to white men, Latina women earn only 55 cents and Native American women earn only 60 cents, right? They have the latest of the equal pay days in the year. Ms. Ghostgraves, in your testimony, you pointed out that 60% of workers in the private sector nationally are either forbidden or strongly discouraged from discussing their pay with their colleagues. You were talking about this a bit earlier, but can you explain a little bit more why that is the case and why Congress must act to protect workers from retaliation and discussing their pay with their coworkers?
Well, despite the fact that we have laws like the National Labor Relations Act, some employers just maintain policies that say that you can't talk about your wages to anyone, to your coworkers, and that you can't make inquiries even about wages. And so what that means is that employees are left in the dark. And it's a thing that I think isn't good for organizations, because you'll have some employees guessing about where they stand, assuming that they're being paid less because they're operating without any information. So the Paycheck Fairness Act would prohibit these sorts of retaliatory bans where people are told and sometimes made to sign documents that say you won't talk about your wages and there will be a penalty if you do.
So the issue of full disclosure is good for everybody, is what you're saying. I wanted to see if you wanted to take some time. We ran out of time to answer the question about data. We have a few seconds left.
Sure, thank you for that, because that's, sunshine is a good disinfectant, and that's one of the reasons to provide that data. It will make our civil rights enforcement agencies stronger. It will enable them to identify trends, sectors that seem like outliers, and sometimes employers that seem like outliers. But it also, I think, will be important for employers. Sometimes employers might think they are doing the right thing, but actually doing an analysis, taking a look, allows them to make a correction, the sort of corrections that I think Ms. Olson says her clients want to make.
Thank you. I yield back.
Thank you. I now recognize the ranking member of the full committee, Representative Fox, for your 5 minutes for your questions.
Thank you, Madam Chairman, and I thank the witnesses for their testimony on these important issues for workers around the country. Ms. Olson, from your experience studying the issue of compensation and advising clients, are employers diligent in fulfilling their legal responsibility not to pay different wages because of the sex of the employee? And what steps do employers take to ensure they're not discriminating in this manner?
Thank you for your question. Here's how I would answer it. The vast majority of employers that I work with, that I know others are working with on these issues through both general groups, where we talk and share best practices, are all working with employers who have a deep commitment to equal pay. And that commitment comes not just from the law, but from wanting to do the right thing for their employees, which is also good for their business. And the kinds of things that they're doing, which is a consistent, ingrained sort of practices throughout their workplace, include education and training and development of managers, tools to assist managers in ensuring that whether they're interviewing a new employee or potential employee, or whether they're doing a performance review, which is going to relate to a merit increase potentially, that those decisions are focused on legitimate business-related reasons, not any other reasons that would not be relevant. They're also building new career frameworks within their compensation systems. They're also reviewing their job descriptions against job requisitions, against also job requirements, to make sure there's accuracy and validity in terms of what's being done. They're also including different stages of a review on a regular basis of individual manager decisions, as well as overall compensation decisions in any year, to make sure that in fact there aren't inequities that aren't able to be explained by a business-related factor other than sex.
Thank you very much. Your experience is the same as mine. Ms. Olson, HR 7 directs the EEOC to collect this employee pay data on many levels, including hiring, termination, et cetera. A similar data collection was mandated by the Obama administration, which the EEOC later discontinued. Do you agree that requiring this additional reporting of employee pay data to the federal government will create large compliance costs with doubtful utility in combating pay discrimination?
Thank you, and the answer is I do. And I do based on the analysis that was done at the time of just a subset of the information that HR 7 would have employers collect. On just a subset of it, just information on pay, for example, the estimate was $700 million for employers to put in place policies and practices and changes to their HRIS system. The EEOC itself said it had to invest over $5 million in changing its own system to be able to accept the data. Even after it was accepted in 2019, September of 2019 for 2017 and 2018, after review of the data, the EEOC determined that it really had no benefit or utility. So collecting data for data's sake in a very high level without getting into specific job titles and job functions to be able to compare jobs that are actually equal or substantially similar, and then also identifying business-related factors. Without doing that analysis, the data is costly, but useful.
There's a difference between data and information. In 2013, Ms. Olson's Supreme Court in the Nassar decision said that in retaliation cases, lessening the causation standard could contribute to the filing of frivolous claims, which would siphon resources from efforts by employers, administrative agencies, and courts to combat workplace discrimination, end quote. Do you agree with the Supreme Court's comment on lessening the causation standard in retaliation cases? And if so, how does this relate to the Protecting Older Workers Against Discrimination Act?
The current standards that are present with respect to both retaliation under Title VII, as well as the Age Discrimination Employment Act, and I see my time is almost up, so I'll just finish the sentence, is appropriate and has led, in my experience, to litigation that has been successful when it should be with respect to showing that employers used inappropriate factors in terms of their decision making. I don't believe a change in the law is necessary or would be helpful to workers.
Thank you very much. I can't see the time, but Madam Chair, I'll assume that I'm out of time. And
that is correct.
Thank you.
Member Fox. I now recognize Representative Jones from New York for 5 minutes for your questions.
Thank you, Madam Chair, and thanks also to Chair Adams for both of your leaderships. The issues raised here today impact far too many people in this country. According to a study by the Center for American Progress, women are the primary sole or co-breadwinners in 64% of families. I was raised by a single mom who worked long hours for low pay to provide for our family. So wage and gender issues hit especially close to home for me. When I hear about the gender and racial pay gap, I think about the hardworking women who, like my own mother when I was growing up, have to provide for their families. In my district, in Westchester and Rockland counties, where it is extremely expensive to live and where low wages are therefore particularly burdensome on families, single mothers are the sole breadwinners in 13% of households. So, Ms. Goss-Graves, some of my colleagues on the other side of the aisle assert that in seeking to correct the injustice of the gender wage gap, the Paycheck Fairness Act will actually harm businesses. Can you address this claim?
I actually think that Ms. Olson made the case for why paying people fairly is actually a business good. It is a thing that will help you retain your talented employees. It is a thing that will help you ensure you have more diverse rooms. But not every employer is there. And so we can't, I think Congress can't craft laws for the best minded employer that is going to always make the right business decisions. It has to craft laws that ensure that the incentives are there for people to be paid fairly the first time. A really tough thing to accomplish in the area of pay because it is so secret and because all of the information lies with the employer. So we can't be in a situation where it's just sort of trust us, we got this. We have to be in a situation where there's information that our civil rights enforcement agencies have and where employees can have conversations about their own pay. Something has to give so that it can be detected when unfairness is happening.
In short, there's no defensible reason to maintain the status quo. Data shows that Black women typically make only 63 cents, Latinas only 55 cents for every dollar paid to a white man. And it's clear to me that we need to strengthen the Equal Pay Act to ensure that women, and especially women of color, are compensated fairly for their work. Madam Chair, I ask unanimous consent to enter into the record a letter from the American Association of University Women urging support for the Paycheck Fairness Act.
Without objection.
There's no excuse for discrimination of any kind in the workplace. That includes age discrimination, which is one of the most common and sadly most accepted forms of discrimination in the workplace. This too is personal for me. My grandmother had to work well past the age of retirement just to pay for the high cost of prescription drugs and medical procedures not fully covered by Medicare, which, by the way, is why we need Medicare for all. One of the jobs my grandmother took was as a food service worker in the East Ramapo Central School District, a job she worked after my grandfather had died of cancer. I shudder to think what would have happened had her prospective employer determined she was simply too elderly to take the job. I represent parts of Westchester and Rockland counties. According to the 2020 census data in my district, over 171,000 of my constituents are seniors. So Ms. McCann, when an individual brings a claim for multiple forms of employment discrimination, such as gender, race, and age, how do courts currently sort out the differing standards of proof and remedies in cases such as these? And does the Protecting Older Workers Against Discrimination Act clarify and simplify the adjudication of such claims?
Yes, right now, confusion reigns. When someone brings a claim with multiple protected categories, so like an older woman, like your grandmother, the courts have to apply two causation standards. And in fact, some courts have gone so far to say they're not going to even recognize an intersectional claim because the very presence of the Title VII claim, the gender claim, means that age could not be a but-for cause of the discrimination. What PAWADA would do would replace that confusion with uniformity, because all of the statutes which have materially identical causation stands already would now be subject to the same standard, causation standard.
Thank you, Ms. McCann. Madam Chair, I yield back.
Thank you. I now recognize Representative Good from Virginia for 5 minutes for your questions.
Thank you, Chairman, and thank you to all of our witnesses. You know, I think that the four of these acts combined together, and it's unfortunate we have to consider them together versus separately, but the acts would better be called the Trial Lawyer Fairness Acts or Protecting Trial Lawyer Acts. These bills purport to correct problems that are largely non-existent. They purport to fix issues that have been corrected by laws that have been in place for decades. These alleged discriminations that we're hearing about were eradicated largely before I entered the workplace some 30 plus years ago. The fact is that most employers, virtually all employers, pay the same amount for the same work for all people when considering factors such as experience, skills, performance, and other objective job-related criteria. And that's true because it's simply required in a competitive marketplace and to try to retain the most talented workforce for the organization to be as successful as it can be. And frankly, it is the law now. These bills seem to flow from a lack of understanding by our majority on the true practices that exist at virtually all businesses. And perhaps that's from a lack of business experience. I spent nearly 20 years in the corporate world and working through these issues and applying these issues in a fair, non-discriminatory way because I wanted the business and my employees to be as successful as possible. But, or worse yet, this flows from a deliberate intent to be dishonest in representing the facts, or just an outright hostility towards businesses and employers in general. It's been reported that at the close of 2020, 8 million small businesses remain closed today because of the extreme government efforts to crush the economy through these ridiculous lockdowns, shutdowns, and restrictions on businesses. The NFIB has reported that in my home state of Virginia, 25% of businesses have closed. And according to Yelp, they estimate that 60% of the businesses that have closed in 2020 are unlikely rather, to reopen ever again. So my question for Ms. Olson, do you think that these bills that are proposed before us today, do you think that these will help these businesses to reopen?
Thank you for your question. I appreciate it, Representative Good. I don't believe that burdening employers with the unworkable and unobtainable requirements of the Paycheck Fairness Act will help workers in these businesses or any businesses across America. And I strongly oppose it.
Yeah.
With respect,
excuse me, go ahead, continue. No, you continue.
With respect to PWADA, I've described in my written testimony at length, and in an abbreviated form, given my 5 minutes, in my verbal testimony as well, how PWADA is not what it represents itself to be. It is not a worker-friendly statute. It is a trial lawyer-friendly statute. Under mixed motive cases, it is unquestioned that a worker will not receive any injunctive relief that will help itself or any monetary relief as a result of a mixed motive case. With respect to issues that I've covered in terms of the Pregnant Workers Fairness Act, as well as the PUMP Act, I've included my commentary with respect to those in my written testimony. And I would say that there is unquestioned support for employers to provide reasonable accommodations for pregnant workers, including nursing mothers. There are issues with respect to those various statutes or bills that I've described that I know these committees have worked together before on, and to fix certain issues. And I am hopeful that that will continue after today in terms of ensuring that both pregnant workers and nursing mothers have the opportunity to be sure to have reasonable accommodations in the workplace.
Yes, when these, thank you. When these businesses are unable to operate, to reopen, to successfully operate, that discriminates against all workers, and that eliminates wages for all workers and the business ability to provide for the workers who can provide for their families. And at a time of high unemployment, global economic uncertainty, tightening federal regulations, do we think that will stimulate the economy, create jobs, or lead to more growth, adding more regulation, more burdensome regulations for employers?
It will not lead to more growth in either businesses or worker wages. And that's the problem with the Paycheck Fairness Act, for example.
Yeah, Paycheck PFA HR 7 that you're referring to, it says it requires employers to show that pay differential for employees based on experience is a business necessity, and it's just
Representative, your
really
time has expired.
it's incredible to hear the majority talk about business necessity with the way that they have treated businesses.
Representative Good, your time has
lockdowns,
expired.
and this hearing today. Thank
I
you.
now recognize Mr. Bowman from New York for 5 minutes for your questions.
Thank you, Madam Chair, and thank you to all the witnesses. Ms. Bask, you discussed the impact that the PUMP Act could have for Black mothers in particular. As you know, that Black mothers and pregnant women disproportionately remain in the workforce and face less than accommodating workplace environments. In your estimation, how much of the Black maternal health crisis might be attributed to the lack of these necessary accommodations in the workplace?
Thank you for the question. Providing accommodations for, or more specifically, time and space to pump breast milk, along with is one important tool to help Black women, Black mothers, stay healthy and attached to the workforce, along with the Pregnant Worker Fairness Act, which I was mentioned earlier, some of the health impacts and the pronounced impacts that we heard through COVID about the likelihood, the higher risk of complications pregnant workers face disproportionately Black and Latino women as a result of not getting, of developing COVID. So these accommodations in the workplace are critically important, especially now, to help them maintain their health and hang on to their paychecks.
Thank you for that. Ms. McCann, you have stated that the EEOC must do more to fight ageism and that ADEA has become a second-class civil rights law. Is it the case that ADEA provides less protection than other civil rights laws?
Thank you for the question. Well, that certainly was not Congress's intent when it enacted the ADA and modeled its substantive prohibitions directly on Title VII. In fact, Title VII's substantive prohibitions were lifted in hoc verba, as the Supreme Court said, from Title VII. But what we've seen is over the last couple decades, Supreme Court cases like Gross and others have whittled away at the ADEA's protections and have focused on any small differences between the ADA and Title VII to weaken the ADA's protections, to expand its exceptions and narrow its protection.
Thank you very much. Ms. Graves, Ms. Olson suggests that incentivizing employers to conduct self-audits would be enough to address amoral and economically damaging pay inequities. Why is this approach insufficient, in your opinion?
Well, so we've had equal pay laws for over 5 decades. It's not a new idea that you can't pay people unfair wages. What we are actually trying to do is ensure that ensure that our civil rights enforcement agencies have the sort of information that allow them to be effective. So it's an odd idea that you would have a safe harbor for an obligation that is over 50 years old. And the other real challenge is at the heart of our laws are the individuals who are being paid unfairly. So a safe harbor might allow an employer to do the right thing going forward, but for that individual who's not able to recover, that is a giant deal, especially when you're talking about women of color where the wage gap is so large and so stark.
Thank you very much. I yield back the rest of my time. Thank you.
Thank you very much. And for everyone's awareness, we have next Mr. Fitzgerald and then Mr. Yarmouth, and then unless other members return, we will do closing statements. I now recognize Representative Fitzgerald for 5 minutes for your questions.
Thank you, Madam Chair. Just real briefly, I know a lot of the questions have already been asked, but the area that really stands out to me is, this bill will kill the Christmas bonus.
Come in.
And the Christmas bonus is something that's determined in many different ways based on the employer. Oftentimes, it's kind of a consensus compensation that's based on how the company does throughout the entire year. And it looks like HR 7 would simply stop that practice dead in its tracks. And I just wondering if Ms. Olson would like to comment on that aspect of this bill.
Yes, you're absolutely right. You know, any employer is going to be concerned about making any differences in pay between employees based on objective and subjective business and job related factors if HR 7 were the law. Because once you do that, even if you could show it was a business necessity, which again, I believe is an impossible burden, one that's undefined, one that employers are going to have to guess as to how to comply with. The employer would also have to show that they weren't able to give the highest amount of that Christmas bonus to all employees. How is that not possible? And if an employer can't show that they wouldn't have gone bankrupt, what are they to do? It's going to eliminate the ability for employers to actually make differentiating payments to employees based on their individual contributions to the business. And that's not what the American economic system is about. It's not about what job you have. It's about what job you have and what do you bring to it.
Yeah, Madam Chair, a lot of families really depend on that Christmas bonus, that end of the year bonus. And if this bill takes that off the shelf, I think there's going to be a lot of people very upset. I yield back my time. Thank you.
Thank you, Representative. I now recognize Representative Yarmouth for 5 minutes for your question. Thank you for your patience.
Well, thank you, Madam Chair. Thanks to all the witnesses for your testimony and my colleagues for their questions. Ms. Bax, Kentucky has accommodations similar to those in the Pregnant Workers Fairness Act. And in the last Congress, GLI, which is our Greater Louisville Inc., which is our Chamber of Commerce, testified in favor of this bill. Are you familiar with their testimony? And could you expand on, if you are, why they felt this was such an important step forward for mothers, prospective mothers?
Sure. Yeah, so there were a few reasons I recall she laid out in her testimony. First being employee retention, right? That this is a tool, especially now, to keep women healthy and attached to the workforce. Clarity in the law, right? That, we have Supreme Court standard Young versus UPS that requires, as I said earlier, pregnant workers to jump through hoops, provide tremendous confusion for employers. We came together, with the US Chamber in good faith and this is why the Chamber, SHRM, and other business groups are supportive of this bill, because it provides clarity in the law. And, running a free legal helpline, we help women in states with these laws, and we're able to avoid litigation and help them stay healthy and on the job. And this is a preventative tool and exactly how the law should work.
Right, thanks. And I think in our case, we are right on the Ohio River, right across from Indiana. I think you said about 30 states now have these accommodations. I don't think Indiana had those accommodations. So we had workers going back and forth trying to deal with different laws and accommodations, which is not easy.
Yeah, and for multi-state employers operating in Kentucky and Indiana, you need a clear federal law, right? That's why we need a clear federal law for the employers.
And, I think, we talk so much about the desirability of having bipartisanship, and in the last Congress, we had 100 Republicans who actually supported this legislation. So it seems to me we have a golden opportunity to do something that is overwhelmingly bipartisan. The business community supports, women's groups support, and I think would be a very significant step forward. Ms. Goss-Graves, I think your organization provided a lot of the data that we've been throwing around today on the disparity in wages between white men and Black women, white women, Native women, and Latina women. And if I'm correctly assessing it, it showed that of the gap. So when we're talking about 60%, 60 cents on the dollar for Latina women to white men, almost 40% of that gap was basically unattributable to all the things that we've been talking about, and Ms. Olson's been talking about with experience and the differences in occupations and so forth. My question is, and this is kind of off the wall, so I apologize for that. You may not have the data, but do you have any indication? We know that Black women, Latino women often are disproportionately in lower wage jobs, in the hospitality industry and so forth. Do you have any idea about how much of the wage gap would be corrected or closed by a $15 national minimum wage?
You know, I don't have that statistic offhand. What I can tell you, though, is we've done analyses of states that have higher minimum wages, including one fair wage, and have found that in those states, the gap is smaller.
I was hoping that would be your answer, and I certainly think that as we move forward on discussing raising the minimum wage, that we take that into account, that this is one of the ways that we can help correct some of this wage gap that exists between men and women. I have no further questions, so Madam Chair, I yield back the balance of my time.
Thank you, Representative Yarmouth. Next, we have Representative Cawthorn. You're recognized for 5 minutes for your questions.
Thank you, Madam Chairman. It really does mean a lot. I appreciate everyone who is on this call. You know, I think that is absolutely imperative that we as Americans, with our employers and our government, treat everyone with honor, dignity, and respect, treat them all fair and under the law. But I was wanting to ask a question of Ms. Olson. Under the Equal Pay Act, does a plaintiff have to prove discriminatory intent in order for her to win her case? If not, does this make the Equal Pay Act claims easier to prove? And do you have any other follow-up thoughts on that?
You're absolutely right, Representative. Under the Equal Pay Act, it is the only employment discrimination statute that does not require a showing of discriminatory intent. As a result, it's sometimes referred to as a strict liability statute. In addition, unlike the other statutes, under the Equal Pay Act, the employer bears the burden of not just production, but persuasion. All a plaintiff has to show under the Equal Pay Act is that they are performing a job that is the same as somebody else and that they're paid differently. That's it. No other evidence, no other taint or suggestion of discrimination, just that they're paid differently. And then all the burden goes to the employer.
Well, Ms. Olson, thank you very much for your answer. Let me do one follow-up question on that. So in my district, I know I have a lot of companies who reward high-performing workers, you know, with end-of-year bonuses or maybe other incentives. Do you believe that HR 7 would endanger these kinds of payment and rewards? And if that is the case, you know, how do these employers work to retain these high-level employees and encourage them to work harder than their coworkers?
It absolutely would, because anytime an employer makes a payment to a worker, whether it's a bonus, it's an incentive, or it's an increase in pay or some other benefit that is due to, let's just say, that particular individual's contributions that are extra or that are better than another worker. And maybe it's because they're a better teammate. Maybe because they showed leadership on a particular project. Those aren't quantifiable objective factors. And yet, why would an employer risk all this litigation and uncapped punitive and compensatory damages and class actions to reward its employees for those good qualities that are exhibited in the workplace to help all workers and the business? They risk litigation if they do that.
Well, you know, that's something, especially, you know, with knowing with the Equal Pay Act, they don't even have to prove discriminatory intent or some of the litigation they would be facing. I know this would scare a lot of the employers in my district. So, Ms. Olson, I genuinely appreciate your expertise and your time. Thank you for coming onto our committee. And thank you for enlightening myself on some of these issues. So, everyone, thank you very much. And Madam Chairman, I yield back the remainder of my time.
Thank you, and I see no other members, so we'll move on. I want to remind my colleagues that pursuant to committee practice, materials for submission to the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, so by close of business on April 1st of 2021, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the subcommittee or subcommittees or an invited witness may submit materials for inclusion into the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame, but please recognize that in the future that link may not work. Pursuant to House rules and regulations, items for the record should be submitted to the clerk electronically by emailing submissions to edandlabor.hearings@mail.house.gov. Member offices are encouraged to submit materials to the inbox before the hearing or during the hearing at the time the member makes the request. Again, I want to thank all of our witnesses for their participation today. Members of the subcommittees may have some additional questions for you. We ask the witnesses to please respond to these questions in writing. The hearing record will be held open for 14 days to receive these responses. And I remind my colleagues that pursuant to committee practice, witness questions for the hearing must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. So I now want to recognize the distinguished ranking member of the Subcommittee on Workforce Protections, Mr. Keller, for a closing statement.
I'm sure I think Mr. Keller has stepped out.
Okay, I don't see Mr. Keller, so I will recognize the chair of the Subcommittee on Workforce Protections, Dr. Adams, for the purpose of making a closing statement.
Thank you, Madam Chair. I also want to give my thanks again to our witnesses for joining us today. Today's hearing confirmed that women across the country continue to face discrimination in the workplace on multiple fronts. Women, particularly women of color, still face persistent gender-based wage discrimination even after 12 years of the Lilly Ledbetter Fair Pay Act and 58 years of the Equal Pay Act. And far too many nursing workers still do not have basic protections to ensure that they can take the time at work to pump in clean private spaces. This discrimination has serious consequences for our entire economy, particularly as women are disproportionately pushed out of the workforce during the pandemic. Simply put, we cannot continue to rob nearly half of our nation's workforce of the wages they deserve, force women to work far more just to be paid fairly, and penalize nursing workers. Congress has a moral responsibility to pass the Paycheck Fairness Act and the Pump for Nursing Mothers Act, in addition to the Pregnant Workers Fairness Act and the Protecting Older Workers Against Discrimination Act. We've got to take action to ensure that basic workplace fairness for women and nursing workers, and take meaningful steps to finally end gender-based workplace discrimination once and for all. Madam Chair, I yield back and thank you very much.
Thank you, Chair Adams. And I now recognize the distinguished ranking member of the Subcommittee on Civil Rights and Human Services, Mr. Fulcher, for the purpose of making a closing statement.
Thank you, Madam Chair, and to the witnesses for providing the testimony. I spent 24 years in the workplace, largely as someone who had a lot of employees, and so I always learn from these testimonies, and I thank you for participating. Just my brief takeaway. We've already got laws on the books that address discrimination in the workplace. Age Discrimination in Employment Act, Americans with Disabilities Act, the Rehabilitation Act, Civil Rights Act. And employment trends for older workers in America are up, both in terms of the employment rate and in terms of pay. The winners here are the trial lawyers. And I know that my colleagues across the aisle really like the trial lawyers, and so do I. I like them too, just not quite enough to support legislation that otherwise is a solution in search of a problem. Madam Chair, I yield.
Thank you very much, Ranking Member Fulcher. And if you wait, hold on just one moment. There's just one issue we're trying to clarify. Hold briefly, please. All right, thank you for your patience. I would now recognize myself for the purpose of making a closing statement. I also want to thank our witnesses for being here, for your compelling testimony today. Our discussions confirmed that we are still a long way from eradicating discrimination in the workplace, particularly for women and older Americans, and the testimony established that the laws we have on the books are not working. I do want to note that I request unanimous consent to enter a letter into the record from a coalition of stakeholders in support of the Pregnant Workers Fairness Act without objection. And I also request unanimous consent to enter a letter into the record from the business community in support of the Pregnant Workers Fairness Act, also without objection. I also would like to note that during the opening statement, Ranking Member Fulcher, you noted that a concern about only having one witness. I know we were talking about 4 bills today. I would like to place onto the record that the minority did not actually ask for a second witness, and had they done that, we would have certainly considered that request. So today we heard about how pregnant workers across the country continue to be denied access to reasonable workplace accommodations, despite more than 4 decades of federal law providing equal treatment on the job. We also heard how older workers face unreasonable obstacles that prevent them from holding employers accountable for age discrimination. It is past time for Congress to take action to make sure that all workers can earn a living without fear of discrimination. Our discussion today made clear that we must swiftly pass the Protecting Older Workers Against Discrimination Act to restore protections against age discrimination for older workers. Put us back to where we were, restore those protections so people who are discriminated against can get relief. And we must pass the Pregnant Workers Fairness Act so pregnant workers do not have to choose between healthy pregnancies and their wages. These bills, along with the Paycheck Fairness Act and the Pump for Nursing Mothers Act, should not be partisan. They affect women and people of all parties and all backgrounds. Each of us, but disproportionately women of color and Latinx women, we know that. Each of us should agree now more than ever, we must take these bold steps to protect our nation's most vulnerable workers and make sure that all workers can succeed on the job. There being no further business, and I've already noted the possibility of additional questions. Without objection, the hearing now stands adjourned. Thank you again.